Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So I brought my crying towel today in case I have to shed a tear over what the insurance companies are doing to Amber Heard. I'll have more on that in just a moment. So the crying towel is really sort of a joke because I'm not really going to shed too many tears for Amber Heard, but I do think it's kind of funny that after everything that was revealed in the trial, the insurance companies go after one another and they go after Amber Heard in court. And the reason that they do that is because they don't want to have to pay the judgment. Now, a lot of people don't understand exactly how insurance law works. There are a lot of attorneys who don't understand how insurance law works. But generally speaking, an insurance policy is crafted, first of all, stating what is covered. For example, we cover you for bodily injury, and then how much the coverage is for, $300,000, $400,000, whatever the coverage amount is. And we cover you for personal injury. Personal injury is different than bodily injury. Personal injury is, for example, a defamation lawsuit. And again, the coverage amount, $500,000, $1 million, $2 million, whatever it is. Then after the coverage, the next thing that it goes into is definitions. What does bodily injury mean? What does personal injury mean? Any of the terms in the agreement that it has to define. For example, a business pursuit. It might say, a business pursuit means operating a business for profit out of your home. All of those kinds of things are defined terms. And then, after you get to the coverages, the defined terms, then come the exclusions. There is a saying that says, the good Lord giveth and the good Lord taketh away. Well, that applies with insurance companies too. They giveth with the coverage, and then they taketh away with the multiple exclusions. In Amber Heard's case, there are at least two exclusions that they are relying on. The first is the exclusion for intended acts. So, if your neighbor comes across onto your property and calls you some ugly name, and you rear back your fist and smack him in the nose, smacking him in the nose was an intentional act. It's also probably a criminal act, but at least for the purposes of this exclusion, it would be an intentional act. Now, a lot of times, attorneys will try to get around that by saying that he negligently injured the person that he hit. But usually that doesn't work. Usually courts just kind of raise an eyebrow and go, really? But whatever. The bottom line is an intentional acts exclusion excludes coverage for acts that intentionally cause harm. And then the other exclusion that they're relying on is called the Willful Acts exclusion. In other words, they are more likely than not to cover defamation against a person who is not a public figure. Because when someone is not a public figure, all they have to prove is that they were wrong. They don't have to prove that they were intentionally or willfully acting. But in Johnny Depp's case, they had to prove malice, and malice is a willful act. So the insurance companies both say, hey, you committed these willful acts and we're not going to pay you. And we're not going to pay for your bond. We're not going to pay for your attorneys. And we defended you under a reservation of rights. This is another trick of insurance companies. So let's talk about a reservation of rights. An insurance policy has two main parts. One is a duty to defend. We have to come in, pay for lawyers, and defend you in court. and the other is indemnify. We have an obligation to come in and pay the judgment at the end of this thing if for any reason you're found liable. Now, a reservation of rights letter says, okay, we don't believe we have coverage here. We believe this was an intentional act for whatever reason. Maybe somebody got hit with a ball bat while they were breaking into your house, right? We think that's an intentional act. We don't think we have coverage. But we're going to defend you under a reservation of rights, which means if you are indeed found liable, we're not paying the judgment. It's on you. Now, you may wonder how they can do that when the insurance says, you're going to pay for any personal injury or bodily damage. Well, or bodily injury, rather. The reason they can do it is because they've got these exclusions. So these reservation of rights letters are sent. They are usually provided to the opponent in the lawsuit saying, hey, we're defending under a reservation of rights. Now, the other thing that an insurance company can do is they can refuse to defend and indemnify. And, in other words, leave the insured person completely defenseless. And in that situation, the insured can take some action that can sometimes result in a recovery for themselves and for the person that is suing them. But it's a very dangerous position to put an insured in. Now, it looked to me like both the Willful Acts exclusion and the exclusion for intentional acts would have been complete defenses both to coverage and to the duty to defend. But you have somebody who is relatively famous, Amber Heard, and you also have a pretty high-profile case, and neither Travelers nor New York Marine wanted to go see in the headlines, Travelers welches on deal, because that would have cost them insurance money down the road. People would have said, I'm not buying Travelers because they didn't defend Amber Heard. So they did the right thing. They went in and they defended her, but now they're suing her basically for a declaratory judgment. A declaratory judgment is a judgment where there is a contract, in this case the insurance contract, and one party goes into court and says, Judge, we want you to tell the other party that this contract provides coverage or doesn't provide coverage. And then the judge reads the contract, looks at the factual situation, and makes a determination. That's what a declaratory judgment does. So in this particular case, they did the right thing. They defended, but now they're refusing to indemnify. And there is a pretty good chance that they will succeed on those defenses. I have seen a lot of cases involving the refusal to indemnify based on policy language. And usually the policy language is clear enough that it just generally gives the insurance company carte blanche to walk away from a big judgment like there is in this case. So that's the way things look at this point. And I think it's interesting that the very thing that occasioned liability here, the willful acts and the intentional acts of Amber Heard. And again, the jury found these things as fact. It may wind up being reversed, and that may not be the case. But at least the jury found those facts, and I think that those facts are the ones that are going to determine whether or not there is coverage in this case and whether or not they will be on the hook for the appeal and the appeal bond and everything else. So, if you have found this helpful or interesting, I'd appreciate it if you would give me a thumbs up. Leave any comments or questions down below, and I want to thank you for watching. Have a marvelous day.